And so we're going to get started. Without further ado, I want to introduce board member Mr. Travis Donnelly. He's going to take it away and will be the moderator of the panel. Travis, take it away. Thank you.
So welcome. Can everyone hear okay? Everyone hear okay? All right. My name's Travis Donnelly, and I'll be the moderator for tonight's panel, Understanding Your TV Contract. So as professional writers, we don't work for free, and we don't make handshake deals. We have contracts, and they dictate how and when we get paid for our work, and we can't start work without them. As most of us know, some of the terms of a TV contract have been stipulated by the WGA through the MBA, which we negotiate with the companies every 3 years. But then there's also protections that aren't covered by the MBA, and that's what you and your representative need to negotiate for yourself. So our goal tonight is to look at both of these and really emphasize the areas where you need to protect yourself. There's a lot of information we'll try and get through. So we will dive right in. And to help us work our way through it, we have 4 great guests with us tonight. On my left here is Brant Rose. Along with Tuchis Rose, Brant owns Brant Rose Agency, which opened in 2000, representing writers and directors in TV and film. He's one of the best agents in town, I can attest to, because he's my agent. He is also signatory to the WGA's Code of Conduct. So from the Brant Rose Agency, welcome Brant Rose. And then to my right, we have Laurie Espinosa, the head of the WGAW Contracts Department. She's got a vast knowledge of all things contract related, much more than any of us in this room, I'm sure. And we're very happy to have her. She's going to help us out a lot tonight. Also to my right is Grant Scharbo. Grant is a writer-producer. He's a 25-year member of the WGA, and he stopped being represented by an agent long ago, long before it was trendy, and has been negotiating his own deals for more than 5 years. So we're very excited to have his perspective here tonight. And finally, Karen Robson is joining us. Karen's a partner in the law firm of Pryor and Cashman, where she represents not only television and screenwriters, but also producers, financiers, and distributors, and many international co-producers as well. So she's a transactional entertainment lawyer, focusing on film, TV, and all forms of audio-visual content. So thanks. Welcome to all of our panel. Okay, so let's dive right in with negotiating your contract and the question, can I negotiate for myself? Grant, you can.
Yes, you can.
Why don't you tell us a little bit about how you started negotiating on your own and what you found from that experience?
I, like everyone else, started with an agent, a manager, and a lawyer. Back when I was 25% of nothing at the time, but so it was a bargain for me. And then as I sort of progressed in my career, I'm very hands-off from the negotiating. You hear back from your agent or attorney that they got as far as they could, and they really pushed hard. And this is what we got, and we hammered them. And I was wondering, well, why are my numbers not going up? Why has my pilot fee been the same for 5 years? So it's like, I got a series on there. It doesn't make sense. So I learned there's 2 paths that got me here. I subsequently learned that my agent never even countered to the original offer. He would send my quote. He would accept the offer. So that was disconcerting. And then at the same time, my wife and I, Gina Matthews, started a co-production studio, and we were looking to, co-finance television projects in the co-production space. And when we started to develop projects, we got to the point where you actually have to pay writers to write some scripts. And so I went to my lawyer and I said, will you negotiate this deal on the studio's behalf? And he said, well, I'll do it for 5% of your company, this new company we just formed. I thought that was a little steep. So I said, screw that, and so I did it. I got on the phone with the agent and the attorney, and I negotiated a deal on behalf of our studio. And that's when I discovered the key points of a pilot deal. They are what they are. They're not especially difficult. As you get into, MAG definitions, by the way, modified, adjusted, gross. The first two words, the redundancy of the first two words tell you you're going to get screwed. So then the question is understanding how they're going to screw you. So I just, once I started negotiating on behalf of the studio, then I thought, well, I can do this on my own behalf. And it's been extraordinarily productive in terms of my quotes and numbers and what I get paid and my definitions and everything. So, because I finally, in my case, have someone actually working for me, and that's me.
Thank you, Grant. And so now it makes sense to then turn this question over. We'll go to Brant and then Karen as well. So maybe you can tell us about then the value that you bring and following that up, right, to a client as they go through. What do you perceive as some of the differences between, the success Grant's had negotiating for himself and how you approach that?
Well, he's doing a good job. Can you hear me? Is this good? Okay, sorry. He's doing a good job, clearly. So what we can add, I would say, the analogy I've used around the office is it's like doing your own auto mechanic work or plumbing. And in one case, I think a couple years ago, I was tinkering with a car, and I just used YouTube and a wrench, which became the joke around the office, and I literally fixed something that my dealership and my mechanic just couldn't figure out. Now, that was one time in 20 years, but I've continued to go to him because what I'm really paying him for is my time. And I'm also paying him for all the mistakes he's going to have 20 years to make that I can't make. So there's a certain wisdom he's going to have, except for that one case that I solved with YouTube and a wrench. But that's really what you're paying for in sum. Do you add anything to that?
Yes, and indeed there are many, and I have such a variety of clients. There are many clients who have absolutely no desire to negotiate their own agreements. They loathe the idea of conflict or even, asking for anything, and they need the protection of someone who makes them stand up for themselves. Unfortunately, not everyone is made of the same metal. And so that is one category of people who definitely need protection, whether it be an agent or a manager or a lawyer or all of them is a choice. And whether people really need all of those things, there are people, people do. This whole thing we're going through now is sort of illustrating to people who does what in their life a little bit, I think. But as far as the legal part of it, obviously, I find a vast variety with the agents, what they negotiate, and sadly, some of them are very much like you described. They come with an offer, and they go, well, this is the highest at the time they call me, which is pretty soon after, is the highest they're going to go. And I'm going, it then falls to me to say, no, we're going to go back with a higher number, because they don't want their relationship ruined. So, that is not a great advertisement for having an agent and a lawyer, because that's sort of saying in some cases the agent isn't going to push very hard, and some of the reasons for that are on display. But, other agents are very aggressive and maybe even too aggressive and might blow the deal. So it really depends on the situation, the team that's in place, what role you're playing. For some clients, even though they have an agent, I basically make the whole deal,
Yeah, and so to me, I think the takeaway from it is just as writers, and every writer is going to make different decisions in the way they want to move their career forward. Just as you put together your representation, there's a lot of different ways to achieve the end result, which is getting the best contract for yourself that you can. Some people prefer the agents lawyers, and obviously Grant's doing a great job doing it on his own. So, or he's happy enough, right?
I'm happy, yeah.
Yeah. So the point is, there's multiple ways to achieve a good contract, and then there's also another avenue of help available to you because you're all members of the guild. Is we have the Writers Guild, and Laurie, you can tell us a little bit about some of the resources that are available from your end.
Right. I mean, writers are always their own best advocates. So the more you pay attention to your agreement, the better. Even if you have representation, it's important to know what's in there. And that goes from the beginning of the process, from negotiating the contract, all the way through performing your writing services. You know when you delivered. You know when you should be paid. And even beyond that, enforcing residuals and things like that. And the Guild is here to help with all of the terms that we've negotiated in this book, from initial compensation provisions to residuals provisions, credits, of course, and something called separated rights that we'll talk about probably later tonight. So it behooves the writer to pay attention, but also to consult with representatives and the Guild in terms of making sure their contract meets the minimum terms of our agreement.
Yeah, and I think the real bottom line is no matter what avenue you choose in negotiating your contract, the way you get the best contract, I think we'd all agree, is through leverage. And so I'll kind of open it up to all four of you. What do you think is a writer's greatest leverage when they negotiate a contract?
No. In some. It's the ability to go into it and know that if it's truly something you don't, or it's truly something that you can say no to and can live with that decision, then you have all of the leverage. If you don't, then we have to play a more careful game.
Yeah.
And Grant, doing it yourself, have you been through that scenario of saying no and gaining more leverage by doing it?
Yeah, I mean, I what's surprising is when you do say no, it's not the end of the conversation. What I've found. I've gone into situations with absolutely no leverage, other than no, and done well, because no one wants to blow a deal. I've heard about these, blown deals, but I've never encountered one. I've never known someone who's had a blown deal. If someone wants to buy something, they're going to buy it. You're going to come to terms, and that's the way it usually works out. But yeah, you aren't negotiating unless you can say no.
Right. Great. And I'm going to try and keep it moving along because I want to leave plenty of time for the Q&A here. So we'll move on to a bit of Laurie's department. Let's talk a little bit about minimums versus overscale. And Laurie, why don't you walk us through a little bit? You can define Article 13 and 14 for us and how that kind of breaks down.
Sure. So Article 13 basically contains the provisions for initial compensation for both writing steps, such as the story and teleplay format, a specific piece of material that you might write, as well as the weekly compensation due to staff writers on a series. Article 14, on the other hand, pertains to what we call writers who are also employed in additional capacities. So that's just a term of art, meaning a writer-producer, a story editor, something called, the showrunner on the series, the executive producer. Those minimums and also the terms and conditions that apply to those writers are contained in Article 14.
Great. And then, and just to kind of get some of the additional brass tacks out of the way for us, so tell us about how the pension and health applies in each of those cases and how
Okay.
that's broken down for us, just so we have an understanding of that.
So pension and health currently 20% that's paid on top of your writing compensation. So that goes for the individual writing steps, such as the story and teleplay, et cetera. 20% on top of that amount is paid to the pension and health fund. And then in terms of the weekly compensation, all of the money you make as a staff writer is subject to pension and health contributions. And in terms of a hyphenate, a writer-producer, compensation pension and health contributions are made on what we call the 14K minimum. So the amount of the minimum that's been attributed to your services as a writer, in a sense, it's been carved out of that overall amount you make on the series, and contributions are due only on that amount.
And there's a cap.
There is a cap, as always, as with all projects. There's a cap that once contributions have been made on a certain amount, then it cuts off and the company no longer makes contributions.
Great. And when it comes to episodic fees, this is open for any of you that deal with these. When we look at episodic fees and we calculate overscale, why don't you explain to us a little how that works? Karen, you want this one?
Well, I mean, I think it's been very interesting, you know, since the new provisions about span, everyone, I think, focuses a little bit more, because the whole idea of an episodic fee is that for people at certain level, co-producer up, basically, will be offered in their deal as it's presented to them, well, we'll pay you $12,000 an episode, $15,000 an episode, $25,000 an episode. And so that, sounds like it's overscale because there's a minimum weekly amount. And the issue, and maybe I'm leaping into another point, is that it is overscale unless it drags on and on and on and on and on, that writing of the episode. But so overscale is just a term for the amount that is above what the WGA minimum for that job is.
Right. And I think let's kind of move into an area that I think that everyone's paying a lot more attention to, which is in streaming, the way streaming specifics work, because that's a bit of a different animal than most people are used to now. And Laurie, I want to flip it back over to you. There's a series of the ad-supported streaming, the budget tiers, how many subscribers you have to reach. Walk us through how that fits into the world right now.
So ad-supported basically means you don't pay a subscription to get it. So it could be Facebook, it could be Crackle, YouTube. For those platforms, the Guild currently does not have minimum compensation provisions that apply to that. There are certain other terms that apply, basic terms, but essentially our side letter says that the initial compensation for those platforms is negotiable between the writer and the company. So it is really important to pay attention, especially in that case, to the budget for the program, contact the Guild, find out what terms you should be getting for that. We currently do not have terms and conditions for that. On the other hand, when it comes to subscriber platforms like Netflix and Amazon Prime, obviously, but there are various other ones as well, the Guild does have terms and conditions that apply to that, and they look a lot like television, as long as the program meets the criteria for what we call a high-budget subscriber video on-demand program. Catchy. And essentially, those programs have to be at least 20 minutes in length. They have to meet certain budget thresholds, and they have to be dramatic. And what we mean by dramatic is not just serious, but anything that's scripted. So comedies or dramas are what we call dramatic. It's a little confusing. So we have, minimums, residual provisions, separated rights provisions, everything that applies to those programs, just like we do for television.
And I think especially as the streaming new world continues to grow, one thing that's important to point out, I think, is even if you do have great representation that you trust and do a good job for you, whenever you have a question, don't hesitate to reach out to the Guild. I think we get cautious about doing that sometimes, but we shouldn't. The Guild is here for us. The staff are way smarter than most of us, certainly than me. But reach out whenever you have a question and don't hesitate on that kind of thing. I'll to Grant, Brant, and Karen, I'll lay it out as we look at streaming and where things are going. What are the key issues that you're starting to see more and more? Where are the trends heading? And what are the things that you have to push back on or make sure your clients are aware of right now?
Do you want to start, Brent?
Well, I'd say just in general, this may be more issue spotting than problems. And thankfully, we haven't had too many of them yet, but I suspect they will grow, because I think we're always in an arms race, really, between sort of what the companies can do to get right up to the line but not over it, but it's not really a desirable consequence of what the Guild meant to do, and then the Guild, thankfully, closes that loophole, and we just keep going and going and going. So, right now with the rise of streaming, we're seeing, and I don't mean to jump too far ahead to your pet topic, right, mini rooms?
Yes,
And,
we'll get there.
But we're seeing more mini rooms. On shorter orders, we're seeing more shorter orders too as well. So, I laid out really 4 points, but tell me if I'm jumping too far ahead.
No,
I
go
really
ahead.
geek out about a lot of this stuff. So, I'm going to make sure I didn't forget this stuff, but one would be just protecting your overscale, and I can unpack that a little more. The span rule, especially if you're not covered, I can talk about that in a sec, and the options and exclusivity rule, especially if you're not covered there, because those last two things were designed to protect people, but above or below a certain income level. So if you're above that income level, you may want to enjoy those same protections. Do you want me to dive in more to these? I don't want to overtalk here.
No, keep going. You're fine. You're good.
I just think, well, let me put it this way. One of the issues I think that will start to come more is you'll see in mini rooms, because there's mini rooms of all stripes, right? Some are for an actual show. We sometimes call them a pre-room, where it's before a show's been picked up, but they're using it in lieu of a pilot as a kind of a proof of concept. So they might be tasked with just a pilot. Maybe you're in there with the showrunner just banging that thing out, or you're doing that plus some backup scripts. Or in one case, I think over at Starz right now, they're doing a whole season worth of scripts to see if they're going to greenlight it to series. So one of the things you might see is the streamers might come to you and say, well, you're going to be paid scale. I mean, just scale. Let's say, I don't want to get too far in the weeds, but let's just say you're normally $20,000 an episode. So to get your weekly fee, you divide that by 2.4. That's the span rule. So you'd be 80, I think it's 83.33 per week. But since they're doing 20 weeks in a mini room, they're just going to pay you the minimum scale, which is $69.67. I get that right? For an Article 14 20-week writer. And they say to you, no, don't worry about it. We're going to make it up to you if and when it goes to series. And when it goes to series, because of the span rules we talked about, you'll actually be taken care of and made whole. But if it doesn't, that's all you got paid. So, that'd be like me asking, Frank Gehry to draw up the plans for my next dream house, but telling him I'm going to pay him at the rate of his lowest draftsman, at $80 an hour. Oh, but if I decide to build the house, then I'll make you whole. It's cool. We all know what Frank Gehry would say to me. And I think you should be saying the same, which is, I'm going to be paid what I'm worth at all times. Otherwise, it's going to create this tier of it's speculative work at scale to be made whole later. It's just another way to sort of suppress or depress wages until they absolutely have to pay it. So I think that's the one. And then in terms of the span rule, that you guys talk about that more in Article 67, but I would say if you're above that level, we're going to want to all start asking that you be covered by it anyway.
And do you see some of the same type of things on your end, Karen?
Yes, all of the things that were just spoken of. I'd like to talk a little bit about exclusivity, because I do represent some writers who write feature scripts as well as television, and I do find that most agents pay absolutely no attention to those provisions until they bite them, because this reason is actually another. With streaming, it's not just that the seasons are short, it's also that sometimes the period of time spent is longer, and span looks after it to a certain extent. But there's also provisions buried somewhere, usually in the long form, because very rarely is it brought up at the deal making, and it should be if it's relevant to you, is what can you do during the time that you're contracted? Now, obviously, most people say, well, you're exclusive when you're in the writing room writing. And it's hard to sort of say, no, I'm not, unless you're at a certain level where you can say, I have this show and I'm just consulting on this or whatever. But it's like, what can you do in between? And there's plenties of in between. There could be a hiatus. There can be a period between the writing room before production. There can be a period after. There's all varieties depending where you are in the scheme of things. So you want to look for the exclusivity language, and you want to see if it says that you're non-exclusive except during certain specified periods. And you want to look for words like production, pre-production, post-production. And you should be non-exclusive during post-production at least, and in between the times that you are exclusive. And it usually will say that you're in first position if they want to call you in and stuff, but it needs to say what you're exclusive for, and just look for that too, because it sometimes just says you're exclusive in television, which is good if you're a feature writer. but you want to look for those words, and I feel that they're not usually negotiated in the deal terms going back and forth between the agents. Sometimes they are, particularly when you already have another commitment and people need to say, well, look, I have already this script commitment, and if I have to rewrite. So that kind of exclusivity, I think, is important.
Yeah, and it seems like these have become far bigger concerns as we see shorter seasons, and there's so many shows that have the shorter seasons, which kind of leads us right into talking about episode order sizes a little bit. And Laurie, tell us how the NBA defines short seasons and what protections we actually do have already in place.
Sure. So in terms of what the span provision defines as a short season, for broadcast television, it's 12 or fewer episodes in a season, and for everything else, it's 14. So for new media platforms and cable, it's 14 or fewer episodes. And we are trying to keep up with this problem. In 2014, we introduced the options and exclusivity provision, which has some of the protections that you're referring to. Mm-hmm. And then just last time around in 2017, introduced SPAN. And I assume most people have heard of it. It really is designed to sort of rein in the amount of time that a company can spread a writer's episodic fees, which formerly under the old network television model, your episodic fee essentially covered about 2 weeks of work. So you could count on, with a $30,000 fee, getting $15,000 a week. But with just the splintering of television the way it is now, oftentimes you're just making minimum, and that was the operative force that we noticed happening over the years. And what SPAN did was provide that your episodic fee, that your negotiated episodic fee, can cover no more than 2.4 weeks per episode, as you mentioned earlier. So another way to think of it is if you have 10 episodes ordered, the span of time over which your guaranteed fee for those 10 episodes can be paid is 24 weeks. Once you get beyond the 24 weeks, for each additional 2.4, you get another episodic fee. So it is significant in that it limits the amount of time that a company can spread those fees out, but there are certain caveats, one being sort of a threshold compensation amount, which is $350,000. So if you make more than that, then you won't be protected by SPAN. The hope was, of course, that writers who made more than that would have the leverage to be able to negotiate for similar provisions. I hope that the facts bear that out as we go on. The SPAN has been in effect for a little over a year at this point. And also, it does not apply to story editors. So even though a story editor is a hyphenate under Article 14, this provision applies specifically to writer-producers, so co-producers and above.
Got it. And so we've kind of talked about some of these things. Really, so much of this with short seasons, and you touched upon mini rooms, which we'll get into a little more in a second. But so much of this is really about the awareness. Recognizing that you need to ask for these things, and you've mentioned hiatuses. The producing end of it as well. Grant, in the contracts you've done, the short season stuff, what's the areas where you feel like you have to have the most awareness on the things that you can really negotiate a little bit?
I've never done a short season deal, to be quite frank.
Okay, so luckily,
Yeah.
very few. Okay.
Yes.
Well, and so this is a broader question that extends beyond just short seasons.
I've never done a staffing deal.
Okay, right,
So-
right, gotcha. Well, in all of the negotiations that anyone's done, what are the things, the markers, the pitfalls we see in companies failing to honor SPAN, paying appropriately? Have we run into that, or?
I think SPAN is good because it's something you can point to very specifically. I mean, before that, of course, there were lots of problems. And even now, it's a bit like, that producers say, well, I'd like a free rewrite, and that's not permitted under the Guild, but it became entrenched in the business, especially the feature business. So I feel like there's a little bit of that still with, it's a bit harder because there is a writer's room, but once the writer's room, sometimes people are brought back in to do this, to do that, and people don't like to say no. And so I do feel that, some people do take liberties with where's the distinction between, you know, people talk about, well, we're closing the writer's room, but that doesn't necessarily mean that the writers aren't going to be called about doing extra work. And so I think there's a bit of wiggle room that some people,
And that's the part where I say writers really need to take ownership of that and let us know what's happening, because we won't know otherwise. So, and, you know, with SPAN, we really do want information about how this is being applied, whether companies are complying, especially going into next year's negotiations.
And as you said, because it's relatively new, the more information we can gather about it, the more it helps us as we move forward into the next negotiation.
Right.
So don't hesitate to share those things with us. And speaking of new territories, I think we'll move into mini rooms a little bit, which is very much how many people have been in or part of mini rooms? Yeah, they're becoming more and more common, and frankly, they're a little bit of the Wild West out there, right? Why don't you tell us, Laurie, what MBA protections we do have for mini rooms?
Sure. Essentially, they aren't a per se violation of the MBA as long as the company's paying the appropriate weekly minimum. What happens, though, is oftentimes you're not given the weekly minimum that you're accustomed to, or you're not given the title you're accustomed to. They might try to call you a staff writer for the period of time that you're in a mini room, when you actually are going to end up being a hyphenate on the series if it gets picked up for the next season. So it does take a lot of diligence and also probably some tough negotiating to make sure that you can either get the fee that you're accustomed to, or at least negotiate something over scale and not be stuck at weekly minimum. The other protections that come to mind are credits protections and problems, because if you are breaking stories, even writing material during that mini room, tracing that and figuring out what gets used during the next season, making sure that you're credited appropriately. The Guild will help with that, but it is a thorny issue that comes up in these type of rooms.
I'd just like to add something to that. For writers creating shows, and even people who are creating shows maybe for the first time, not people who've reached the august showrunner status, the old deals or the network deals, your rights on your show when you sold a show, say you wrote a spec script and then you sell it to a production company or you option it or whatever, and you negotiate all the terms of the deal, a lot of the obligation of the network or whoever it is who's buying it to have you on the show as an executive producer and to get a certain royalty and to get a back end is credit dependent on the pilot, or sometimes the first episode if there isn't a pilot. So this is an area which is a bit endangered by the mini room, because if you start to have writers on the pilot with you, are they entitled to credit? Is that going to endanger? And everyone always says, oh, well, a network, if it's not working out, they're going to get rid of you anyway. Yes, but it's one thing to be gotten rid of. It's another thing to be gotten rid of and not get any fees because you didn't get full, or not get your full fee because you only got a shared credit and not a full credit.
And I'll just add in there also not getting any credit, which we hear of happening sometimes in many rooms too. You go work on it for 10 weeks and then then you don't move on to the show, when it comes about, and then you get no credit for having been associated with that show whatsoever, and you have a big hole in your resume, even though you've been working. So that's an important part too. Brant?
That's something I would jump in and say. Also, if you find yourself looking at a deal for a mini room, and this is even before mini rooms, I can't remember what we called them back then, but what I was focused on, in addition to exclusivity, and what you could do is, hey, if I'm going to be in the mini room and it goes to series, I want to be on the ship. So you got to have some kind of essentially the equivalent of the lock for the creator. But for somebody in the room, if you go to series, and they'll push back and say it's got to be based on this room, because technically they could wash the room out and put up a new room. So if it goes to series based on this room that I was in, then I'm along for the ride. I'm going to get my episodic fee on the series for the whole first season. So make sure that's in there. What I learned as a baby agent was it wasn't just about marking up what I saw. It was about all the things they didn't even put in for me to spot. That was the stuff that I needed to learn.
and we're especially seeing that in many rooms where there's really not much of a framework or a set of parameters in place at the moment. And so yeah, it's kind of along the lines of what you're saying. How do we protect that overscale compensation? One of the things you were talking about before as well was like, accepting like, oh, we'll make you whole once the show reaches, anyone telling you that that's the way it works is incorrect. And frankly, I've talked to lots of people and lots of showrunners who didn't even realize that there was another option. They were just told, oh, no, this is how the mini room works. You'll be made whole later, so just don't worry about it. So spread the word. Showrunners often don't have this information either because it is new territory, and everything can be negotiated, and showrunners can ask that people are made whole right from the start, and they should do that. So that's my soapbox bit.
Yeah, and as we were saying, we started this from saying, well, that's a bad deal where you're only being paid a minimum and it's against your normal fee. An even worse deal is where you're only being paid the minimum and nobody wrote down that you actually get the rest of it when it goes.
The thing about the episodic fee generally is it's for episodes produced. So to the extent nothing's produced, no one's going to be made whole from that standpoint. So it's always better to try to negotiate something for those weeks you're actually working.
Made whole is like modified adjusted.
Yeah. Made whole. One sort of, I guess, mitigating factor is if the company tries to, if you do get picked up for the season, they do go into production and they try to credit those mini room weeks against your episodic fees, those weeks are going to be included in the span calculation when we're talking about 2.4 weeks per episode. So that at least will go part of the way toward making you whole, assuming all of those conditions precedent happen and it actually goes into production.
Yeah, and so again, I think the bottom line is we're rolling out a lot of information here. The real underlying tone is be aware of these things. Make sure you're asking someone. Call the guild when you have questions. Ask your reps to look out for these things because there are no set rules really on mini rooms right now. And so be aware of what they're not even offering you as options. Are there any other little things that you guys want to, before we move on from mini rooms, things that we need to look out for?
I was just going to mention of mini rooms. I mean, just look at those words, option and lock, and they're quite different in meaning. Option is usually a one-way option on the behalf of the network or the producer to pick you up or not pick you up at their choice, and lock is a word that obviously a lot of you will be familiar with, where you are guaranteed to be carried over, sometimes for one season, sometimes for more than one season, and it gets more complicated than that, but just those terms.
Another thing that we've seen, and I just want to nip this in the bud if possible, is studios hiring people as consultants and non-writing consultants in a room like this. And so
all the time.
You won't get pension and health contributions on that. It's a nightmare. So if you are presented with one of those types of agreements, please call the contracts department.
You're finding that where it's sort of like a punch-up scenario, like, oh, you're just going to come in and advise, or
sometimes it's actually
ideate.
Sometimes it's actually before the series is picked up. Sometimes
Right.
it's during. It's any way you look at it. I mean, I think companies are trying to get out of sort of guild jurisdiction by saying, well, no one's actually picking up their pen and writing.
Yes.
But that's not a requirement for what constitutes writing services under the MBA.
Great. And so now let's go ahead and move on to a couple more topics before we open up for the Q&A. And one of the things that I do want to talk about is separated rights. And Grant, you and I talked about this on the phone. You've dealt a lot with separated rights in contract language as well
Yes.
on your end. Let us know how you start us out by how you deal with it.
I mean, I deal with it both in deals that I make for myself as a writer. As if you've written a pilot, you know that the first check they are very eager to send out is $100 that purchase these rights. And so if you've sold, and correct me if I'm wrong, but if you've sold a pilot for more than for the upset price, more than a certain percentage over the minimum, then you lose all rights. You have reserve rights that are yours unless you sell something for the upset price.
It's very tricky. So separated rights, essentially the concept is certain rights are separated out from the copyright which the company owns in the U.S. and the writer retains them. With television, what happens often is the company will pay an upset price, which allows them to negotiate directly with you to acquire your reserved rights. And so it's become sort of more of a bargain throughout the years. When the upset price was first instituted in 1966, it was much more expensive. So it didn't happen as much until around the 90s, when companies routinely started paying the upset price, because it's not that much more than minimum. And they also, what happens is once they pay the upset price, they can negotiate with you, pay you a separate consideration, and have you execute a separate agreement whereby you sell all your rights, and oftentimes that separate consideration is nominal, $100.
It's $100. And
Right.
it's kind of an end around the NBA.
It's something to be, this is another place where, writers can advocate on their own behalf or call the guild, but it's very common now.
So what it
happens often.
means for writers is that if after 30 months, most of the rights have reverted back to you, there's nothing you can do with your script because no one can buy it without those separated rights. So what that allows, and I'm not saying it's fair or unfair, but the reality is if you want to sell that script then to another studio, you have to first negotiate a deal with the first studio, and they're going to want to be reimbursed for the pilot fee, and they're going to want 5% of MAG, and they're going to want $5,000 an episode in perpetuity. So that's the deal, and it's frustrating because the right to do anything doesn't come back to you.
Right. You end up
after 30 months.
with split rights. So
Yeah.
the right to make a series might revert to you if the company hasn't made it, but all of those other rights, the publication rights, the merchandising rights, the right to do a theatrical motion picture, all of those most likely were acquired by the studio. So you have this splits.
But no one will touch it without those rights.
Right. So, I mean, the good, I guess there's a slightly good part of that, which it means that you have reverted series rights, you can shop it around. If you can find someone who's going to be willing to negotiate with the first company to get those rights back,
Yeah.
then you can do it. It gives you some leverage, but it's not the way it was intended to be.
But they're open to it, and they'd rather get something back than nothing, and so they're certainly open to the negotiation, and it's pretty standard. But it's not, tends not to happen overnight. They have to get approval from their creative executives, even if this is a project that's been dead for 5 years. They'll say, oh, I have to get creative approval on that. Like, they didn't give a shit about it for the last 4 years.
Yeah.
Well, and
They don't want to
Brant,
be made a fool of when it's a hit on another.
Yeah, there's that.
For sure.
and Brant and Karen, on your end, from the negotiating end, when you guys approach this, what's your approach to the separated rights issue? And
I would say, I mean, the studios have been so generally intractable about it that the best case we have been able to make so far is if you already have a pre-existing career in another field, you were a playwright, you were a comic book, novelist, and you could then say, hey, we're gonna also pull those out because we actually have this other career where we could legitimately exploit it. The answer, if you don't have that, is usually like, oh, is he a comic book writer? Okay, no, they'll say back to us, well, why would he need him? We need him because we're going to hold things up for the 50.
Because
sometimes
we're
it's $50
Disney.
that we paid you.
I mean, the other thing you can ask for where people have a career and they won't give them back to you is towards the back of the agreement when you get into language about beyond, selling them the right to make, say, we're generally talking about a dramatic episodic series. There's obviously sequel, remake, and other exploitation, which should never be forgotten, and which is not something the agents usually negotiate. This falls to the lawyer. And so if you are a playwright, or if you can often at least negotiate some kind of attachment to that, some first opportunity to, if you are the creator and entitled to separated rights, that you will get to be the playwright or the novelist or the this or the that. And that's a compromise that they will sometimes accept. It is very, very difficult not to just take the $100 check. I mean, I don't think is what was intended, because the whole idea of signing a separate agreement is not that you sign the separate agreement at the same time as signing the agreement from the series, but that is how it is interpreted.
I would say that, just to reinforce that, that is one of the things I look for, because it's often left out of the contract, the first opportunity clause. There's no stipulation that it has to be in there. So it's one of the first things I look for, and I would say specifically, say first opportunity on all future iterations, and also that this is a rolling right, meaning, so if they do a sequel, a prequel, a remake, if it's a film, they take it to series, they take it to film, becomes a Broadway play, SpongeBob musical, whatever it is, that you get the first opportunity, and typically their language will say to negotiate in good faith in accordance with customs and practices and standards in your quote and blah, blah, blah. But at least get that. And the rolling right says, if you did the SpongeBob series and then you did the SpongeBob musical, as long as you've done the latest iteration, you then have the right to do the next one. If you take a pass on it and say, I want to sit out the musical, you don't retain that right anymore. So if they take the musical and then turn that back into a film, you're not there for it. They can go to anybody they want. But that's
But then you can
where all the
ask for
future money is.
a passive payment, which means that you do get an additional payment. Now, the Guild does provide you some protection on some of these things, but you can always ask for more. And when you see that, what we see around us, you can see that a television series can have an incredible life. It can be a movie, it can be a musical, it can be so many things you can't imagine.
And Laurie, did you want to add anything on what from the Guild perspective on that, or are we pretty well cover it?
I think that covers it. It's a really complicated area of the agreement, though. It's akin to copyright. It's related to the principle of copyright. So I definitely recommend calling the Contracts Department to talk about it more. And if you do have a particular interest in, say, retaining the publication rights, that is something oftentimes a writer can negotiate for. The more leverage you have, the better, like anything else.
The Guild actually has an amazing resource. That's how I learned it, was the pamphlet you guys have online.
Yeah,
Understanding Your Separated Rights. There's like a
Yes.
flow chart that looks like chemistry on there.
Yes, yes.
So
Great. And so the one more topic we're going to touch on, and then we'll open it up to questions. But let's touch just a little bit on development. And I'll start with you again, Laurie. Just pilot fee minimums. What is protected by the Guild, NBA, and what is not?
So for television, when you write a pilot, because of the importance of that piece of material, it basically sets up the central running characters, their relationship, their framework, and the locale, the theme, the setting. Because of the importance of that piece of material, the Guild has basically a provision that says the pilot fee is 150% of the regular minimum for a story and teleplay. The unfortunate part of that is that increase does not apply to high-budget subscriber video-on-demand series. So what happens a lot of times with those series is there is no pilot in the sense that that is produced, goes to upfronts, gets shown, and then the series gets picked up based on that, is my understanding of how it used to work. These days, it's more like all the scripts are written at once, then a decision's made whether to actually go forward with that series and produce. So there's not... Even though there's still a piece of material that sets up that framework, it's still the same importance. It's still the writer that might have separated rights in the series because they've created all the original characters and the format for the series. They don't get that bump, unfortunately. Usually writers are paid more than minimum for pilots, though, and for the reason, I guess cynical reason, that the company wants to acquire the separated rights. So oftentimes they are going to pay the upset price, even though they are not compelled, like Netflix doesn't have to pay 150%, but they're still going to pay the upset price and get your separated rights.
Great. And so with just a couple minutes left, I'll open it up to any of you. Again, we look for... It's all about awareness and understanding and keeping an eye out. Where do we see the trends moving in development deals? What are the pitfalls of the moment that you look for, the things that you highlight in negotiations the most for anyone?
I'd just like to mention maybe 2 or 3 things to do with development deals. I'd like to talk about if-come deals, because I think that confuses a lot of people. And, you know, and a lot of people say, hey, I thought the Guild was against speculative writing. You go, yes, it's not about speculative writing, but it is the idea of making a deal in preparation for pitching a series. Like maybe you're making a deal with a production company and you need your agent and lawyer to work out all the terms, but they're not actually going to pay you any money, and then you're going to go out and pitch it with them. And so that is a, you know, fairly widespread phenomenon, and I'm sure some of you have been confused by it when it's been offered to you. It's like, well, I've written this, or I've got these rights, and I've written a treatment or whatever. Aren't you going to option it at least, or aren't you going to buy it from me? Why should I go and do all this work preparing the pitch and stuff, and then if we don't set it up, I don't get paid anything? So that's, you know, maybe someone like, and the other thing, so that's a development issue. And then the other one is, you know, whether you option something versus whether they purchase it is another issue. I mean, the good thing about the option, even though you don't get all the money, is that it'll come back to you clear and clean if they don't do something with it in a short period of time. But that usually gets muddied because even they option it, they might ask you to rewrite something and then say we own the rewrite. So that could be a problem versus the purchase. And the other thing that's got nothing to do with development, but I'll feel bad if I don't mention it, is with streaming, another big area that is very controversial is the back end. And while this doesn't apply to a lot of the lower level writers, it will apply to anyone who is entitled to a modified adjusted gross back end in the traditional model. And the issue is that many of the streamers pay zero back end. So the Netflix model is sometimes referred to as a cost plus or a premium model, meaning that you're supposed to get somebody's supposed to get, and the somebody is a very interesting 20% on top of what their normal fees are in lieu of a back end. You have your right to residuals, but I'm talking about a participation. Disney Plus, which is the new streamer, has a new model, which is absolutely appalling, which is a point system model. And when you get to the third season, which in streaming is a lot, you get a certain number of points instead, and the points are worth an amount of money, and it's a different amount of money at each season for each episode. So there is a kind of reward for success, but it's like it's been worked out. Anyway, that's the Disney model. I haven't seen the Apple back-end model yet, so I don't know what it looks like. But this area is going to change a lot with competition. There will be back-ends again, I suspect. Part of the problem has been that Netflix won't share any audience information, and I think it's very exasperating for creators when they make a show or they make a movie like Bird Box or something, and they say, well, hundreds of millions of people watch this. So what do I get from it?
I asked a couple. You brought up an interesting point. I asked a couple of showrunners in the past week or two, knowing this was coming up. What were you surprised by the most when you went to Netflix, or what was most troublesome or interesting? But one guy brought up this sort of new back-end system of points, and he looked at it sort of. I would look at it the way box office bonus used to work.
Mm-hmm.
You'd get that alongside your participation in features, but you knew you were never going to see the points. The counting systems were set up to never get there. And he said, I'm sure I'm getting way less, but at least I can see it. I know I got to season 3, and I think it's like 50,000 a point or something at Disney. And if I get to season 5, it's a lot more, something like $500,000 or something, which maybe that's a sign that they'll never get there. But they could be worth something. At least he's saying, hey, it's auditable, I can see it, I know what I'm going to get. And it's probably a lot less than I should, but at least I'm going to get it. If it was the MAG definition, Well, we all know, we all know how that looks, and you may have to sue.
It's pretty good if you arbitrate and you're a participant in bones. It looks pretty good.
Right, right.
It
After
did.
paying the lawyers a lot of
It
money.
did until the judge reversed it. But all
He
that,
only
right.
reversed the punitive portion.
which was a lot.
Yes.
Well, great. So I know we've hit a lot of topics here, and so now we'll open up. We've got mics on both ends, so we're welcome to take questions for any of our panel here. While people are lining up, I'll point out a couple of things. There's some great resources floating around here tonight. Hopefully you got them. There's a schedule of minimums books. I think they may still have some up at the front if you need them. Also, there were handouts on the median salaries and also the pilot salaries. Did you guys see these? These are great resources. Frankly, I hadn't seen numbers like this before to really know across the board what people are making at each different level and what they're making when selling pilots. And part of the way that that gets put together is when the guild has the information. So people seem to not always know this. I only found this out a few years ago, but you send your contracts to the guild. That's how we compile the information, and the reason it's compiled is for handouts like this, so that we can see, wait a minute, why am I making this number as a co-producer when that's 30% below what the median is? We can't put that information together if you don't send your contracts. So digital age, super easy. Attach a copy, send it into you send it to contracts at the
Yes.
guild, right? Send it in. It's incredibly valuable. You don't know how much information we get from that. So spread the word, send your contracts, and we'll start the Q&A over with you, sir. If you can state your name and ask your question.
Reggie Brown. My question has to do with the right of first refusal. Let's say a company buys your work, you write it, and then they want to rewrite, but they want to hire somebody else to write it. Can you elaborate on right of first refusal?
So under the guild agreement, there are a couple of places where that is a minimum requirement. One is in long-form television. If you write an original television motion picture, you have to be offered the opportunity to do the first rewrite at no less than minimum. The other place where it happens is with what we call movies of the week, which aren't that common anymore, but in some places they're actually done quite a bit, like Hallmark and things like that. With that, if you write something original, and this is tied to separated rights, you must be offered the opportunity to write the first sequel, and each succeeding sequel to the extent you get credit on the one before. So it is found in the guild agreement, but it's not everywhere. And so it is important to look at your agreement to try to negotiate that. For theatrical motion pictures, there is an opportunity to do a first rewrite, but in terms of writing a sequel, a prequel, anything, or a series, you'll need to negotiate for that.
All right, thank you.
The gentleman over here.
Hi, I'm Dan Signer. Thank you so much for all the great info. I have a couple questions about the streaming high budget versus low budget distinctions. A couple of questions about it. One, my understanding is if the threshold is 1.3 million per episode, for question number one is that episode regardless of the length of the program? Because if so, that screws comedy writers completely, because basically comedies can be under that and dramas can't really. So that's question number one. Is it by number of minutes
It
or?
is. So we have thresholds in order for a program to meet the definition of a high budget program, for a 25 to 35 minute program, this is found on page 34 of the schedule, it's 1.3, as you said. So that's your half-hour comedy,
Okay.
essentially. For 36 to 65 minutes, that goes up to 2.5 million. And then for over 66 minutes, it's 3 million and above.
So let me ask you though, I've had an offer on a show where they've only heard the pitch or part of the pitch, and they've said this would be a low budget thing. And I don't know how they know that when there's no script and they haven't figured that out.
Yeah.
And the other side of that coin is talking about modified adjusted gross and back end. They figure out ways to put all kinds of costs on later to tell you the show lost money. do those costs apply to the budget of the show retroactively to say this, oh, this turns out this was a super high budget show because it lost $500 million?
Yeah, so there's a lot of minefields in new media, and that's one of them. The fact that oftentimes the company doesn't know what platform it's going to be on at first. It might be television or it might be new media. So, I mean, we will go after whatever minimums ultimately apply. To the extent you were paid less and they get more, then you should be made whole. As far as the budgets go, we're reviewing more of those because there's so many of these provisions that are tied to budget. And so I don't know in particular what items you're referring to, but that is something that we will scrutinize to see exactly what they're including in the budget.
I mean, I'm talking about like no minimums on what the writers on staff can make, on the script, on residuals, on all of those things. When,
Yeah.
how do we know like what costs they're putting on the show and what they're having the network pay within their other pool to keep it artificially under the minimum, but it's not really under the minimum?
Well, what cost they put on the show is something that you can negotiate. So that's part of the pilot negotiation, and keep in mind they're gonna do everything they can to leave themselves open. For instance, you often were sent to states with tax credits to because it's cheaper, right? But that tax credit, unless you demand it in your contract, is not going to apply to the cost of the show. So that just goes in their pockets. And that's like a big one that you need to understand.
Although we would include those subsidies in the budget, like put them back on. They're not going to be able to use the subsidy to get below the thresholds.
Oh, no,
because
no,
they
I'm not
are
talking about the
actually
threshold.
spent on the budget. Yeah. I
But
mean,
the pass-through of the
but that's
tax
very
credit is-
relevant to the MAGR definition, the pass-through of the tax credit. You're absolutely right. Usually they would not apply that. They would not call that gross proceeds, and they would not deduct it as a cost. But it
they
shouldn't.
will,
Yeah.
they will if you insist upon it and they
Yes.
want the deal, yeah.
Not everybody, but a lot of people
Yeah.
will.
So
yes.
just sort of to
Yeah.
wrap it up and conclude, if it's considered a low-budget show,
Yes.
and after the fact, after production, at some point down the road, you can somehow figure
Prove.
that, no, it went over that threshold, do all the protections retroactively fall on the show
Yes.
and the
Yes.
back pay for the entire
Yes.
staff and
Yes.
et cetera?
Yes.
Okay, thank you.
And the guild will help you with that if you can
Yeah.
show. I mean, part of the problem is showing because they're
Access.
not obviously going to disclose their budgets to you.
Thank you.
Exactly, but yes.
No, thank you. Over here.
My name's Rue Sommer. My question's about development deals, and it's largely about how to weight the back-end portion versus the upfront compensation. I've never had a situation where I've had a show go to series, so I don't have any idea what back-end really means and how I should value that in the negotiation. So I'd love for you guys to talk about, the lawyer will kind of present like, this is the number and this is the back-end percentage. We think we should go for a higher number, or we think we should actually go for the back end on this one. And I'd love to get your thoughts on like what the back end really means, because it's just a mystery. It's like a thing behind a curtain
Here's
that
the man.
I have no idea how to value that.
I think as you go into any negotiation, you need to decide which points are the most relevant to your situation, right? So I brought along some notes. Pilot script, pilot producing fee, series services, your series producing fee, the term, Warner lock, two other words to look out for. It used to be that everyone got a 2-year lock, and now they have the. I'll tell you something. If other studios adopt another studio's name for their lock, you know you're getting screwed. There's your consulting fee, which is what you're paid after you leave the show. If for every year that you serve as an EP or co-EP or whatever, you get a 1-for-1. So for every year you serve, you get this fee. Series sales bonus, series royalty, and contingent participation. So as I go in, looking at the landscape of television now, I think the likelihood of a show going the distance and going into syndication, and I mean it's very important for us to understand the business that we are in and how it works and what's happening not just domestically but in the world. And so the reality is, unless you get a bones, the likelihood of you seeing back end is very small. So it's not that I don't negotiate it, and in the event that it does happen, you don't want to shoot yourself. But the numbers I lean into are the ones that are going to last, the most important. So pilot fees, important. Series producing fee, most important. And just scale them. Series sales bonus, it's a one-off, it's a one-time payment. Consulting, if you reach that point, you probably did pretty well, you made some money, not a big deal. So prioritize what's most important to you, but most importantly, understand the business that you're in. That's all.
That's great.
Thank you. That was a fantastic answer.
Good. Let's go right over here.
Rue, you were my captain.
Oh, sweet.
Hi, I'm Josh. I have
Hi,
a question about Quibi. I'm negotiating a deal with them right now, and you had mentioned like Crackle and Facebook Watch, which are under 20 minutes or whatever. It's sort of Brave New World. And with Quibi, it's like these are going to be 10 minutes, maybe. They're saying they're going to be very high budget. They're saying they're going to be on your phone. It's very confusing. So just looking at the numbers, there's few precedents, and I wondered if you could enlighten us if you can.
Yeah, unfortunately, that is something that's going to be negotiable because it doesn't qualify as, because of the length, doesn't qualify as high budget subscription programming. They are high budgets from what I've seen, higher. And so it seems they're also willing to negotiate rates that are similar to those that they would pay in television. Definitely, let's talk. I mean, call the guild and we can talk about what you want to get, because you want to try to emulate those television minimums as much as you can.
But I think it's important, and I haven't done a deal with them either, but I have done some research in preparation, because I'd like to do a deal with them. Because while they are 10-minute episodes, they're going to make 10 of them.
Right.
Right. So I think it's normally for 120 minutes. They're going to make a deal. Now it is kind of a new frontier, and they are very eager for content. So if you're in the position of making a deal with them, I think you have leverage. Regardless of whether or not you have other buyers, if you have something they want. Now, one thing that they do is, so they cover 100% of the budget. And I don't know if this is strictly for writers or producers, but I know that what they've offered is that after, I think, 7 years, it's either 5 or 7 years, all rights revert back to you. And they only take it domestically. So at the end of 5 or 7 years, whichever it is, you end up with 120 minutes or 10 episodes of a show that you can sell worldwide, and that's an easy sale. So you may not make as much up front, but that is actually a field where the back end could be extraordinarily valuable. So I would focus on that back end.
Do you happen to know if that would apply even if it belongs to a studio?
Oh, okay.
No,
No. So
Probably
if
not.
no.
and I want to come back to these words, if come. Two other bad words. If you're putting yourself in a situation where you're going to a studio, the first thing you've done is eliminate all the leverage you have. Studios are not buyers, right? That's what you need to understand. The if come is if it sells to a buyer, a network. Selling to a studio, I keep hearing again and again, these people say, oh, I just sold my script. Oh, great, to who? Whatever studio. Dude, you didn't sell it. What you've done, the only thing you've sold is your leverage, because they're going to put all the terms in place and then they're going to go out and sell it to every, pitch it to every network, and say you have 5 buyers, and they start talking penalties and series commitments and all this stuff. Oh, great, what do I get? You get what you agreed to, and nothing more. So, again, understand the business that you are in. If come bad words, and you don't need a studio. Quibi's not going to, I mean, if you have a sale, again, let's reverse engineer this. If you have a sale at Quibi, there's a dozen studios. Well, I mean, who needs a studio, by the way? They're covering the cost of they're covering the cost. And that's another thing about these cost plus deals. Okay, you're getting me going, but. So you sell a show to a cost plus streamer. Just so we all understand what that means is the streamer is going to cover the cost of that show plus anywhere from 10 to 30%, right? That 10 to 30% goes to the studio, not to the writer, right? So I know of a deal of a streamer who was making a $10 million an hour show, and I know of a studio that was making 30% on that. So that's a lot of money, and none of it is going to the writer.
Well,
And by the way, and they're not doing anything. They're 30%, they're not doing anything. They're not even financing the show. There's no deficit. They're not even providing backroom services. They're
But
just
that-
cashing checks.
but that is where the agents and the lawyers should be negotiating, saying like, and if it's a premium, I get a share of that premium, and negotiating what it is. And people are starting to do that. And there will be litigation too, because if you have a contract saying that you are paid MAGR or net proceeds or net profits, and they are not sharing that premium, I think there's a case to be made that you should.
I'm sorry, I misquoted. It was $10 million an hour. It was 20% of $10 million. So it was $2 million an hour the studio's making for doing nothing.
Yes, and the studio will keep it if you let them.
So we want to get to some more questions before we wrap up here, so we'll go over here.
Hi, my name is Nikki Paluga. A studio recently asked me to write, and I can't remember what term they used first, but it was either a Bible or a format. And then I kept saying Bible, and then they started calling it format, and I thought, what the hell is the difference? So I called the Contracts Department, and somebody referred me to the MBA. I read the definitions 4 times. I still don't understand what the difference is, and there's obviously a huge price difference. So if somebody could just explain the
Laurie?
difference.
Sure. So the format is generally written in the context of an episodic series, where it again sets forth the central running characters, their relationship, the theme, setting, premise, etc., that gets repeated in every episode. And so that's the lower rate you're talking about. A Bible, traditionally, it's still a format, but it's more detailed and usually applies to a closed-end multi-part series. So something where it's thought out from beginning to end, and it likely contains the story for each part, in addition to just that first premise and the characters. I know the terms are sometimes used interchangeably now, and even with episodic series, I've been hearing more that it's Bible. So when someone says that, we like to take a close look at it, because it really is, the minimums are intended to represent the amount of work you're doing. So it's helpful for us to know exactly what you're writing and how much you should be getting.
Well, can I just
There's
add
a
on?
huge difference in the minimums, and
Yes,
that's
there is.
Huge.
Yes, there is.
Can I just
It's weird.
add to that? When I read the definition for a format, I thought, well, I did a very, very detailed pitch for this show, an incredible amount of content, because it was a very strange show, and I knew I had to really, prove what it was. And so when I read that, I thought, well, I've done all of this just in my series pitch work. So if they're asking me to go further, this really feels like a Bible, like really, breaking it out in pretty fine detail.
Yeah, once you start to write individual storylines, especially if those storylines are suitable for use in the episode and you only have to write a teleplay later, then it really looks more like a Bible, and you should be compensated for that.
Okay, thank you.
Great. Over here.
Hello, my name's Sabrina. I had 2 questions. The first one, I had a friend who had a situation where he was on a show that was on the bubble, and because he was a lower level writer, they ended up having to pay he wanted to go to another show and they wanted to keep him, and they ended up having to pay, I think it's called a holding fee if they wanted to keep him. They weren't willing to pay, and so he was able to go to another show. I'm on a high budget stream subscribers SVOD where if there's a season 2, there's a huge amount of time between seasons. Does that apply to me as well? I was there as a staff writer. Would that apply to me as well?
So that goes back to our options and exclusivity provision. There is a threshold for that. So if you earn less than, currently it's 280,000 and 500, then those protections apply to you.
Okay.
So what it says with respect to the option is essentially the option period, they can hold you for no longer than a year after your last payment's due, still a long time. And then after 90 days of the option commencing, you will have an opportunity to seek other employment. You have to follow this procedure that's in Article 67. If the company wants to keep you from doing that, essentially keep you in first position during that time, then they can elect to employ you on another project during that time, if you agree, or they can pay it's not necessarily called a holding fee in Article 67, but there is an amount that's 1/3 of the weekly minimum they can pay along with pension and health contributions to keep you in first position. It sounds to me like that might be something that was negotiated in an individual agreement in terms of a holding fee, so it would be worth calling us so we can look at your contract to see whether at least Article 67 applies.
And then
start from there.
I know that I'm free to develop. I know that was something that I asked for and that I got. But I went to a meeting after my season wrapped, and that was the first question out of an exec's mouth was like, if I was going to even be allowed to like go. Normally people just let you go, right? If you have another, or not. Like, what's the actual, like?
You know, it wasn't such an issue when there were 22 episode seasons and you wanted to take the summer off, probably. So now, just because of the issues we mentioned with short orders and weird production schedules, it has become critical. So it is important to know, first of all, whether you're going to fall within the parameters of our options and exclusivity provision, and if not, to definitely pay attention to those details, the exclusivity and the option provisions in your agreement.
And my second question was about the upset price. Is that something you can turn down? Because it seems to me like a no-brainer to turn it down if the difference in money isn't that huge.
If you want to take the minimum, you can turn it down.
Okay.
But no one's going to buy anything without the separated rights, to be frank.
Yeah.
Okay. Thank you.
Thank you. Next.
Hey, Ken Christensen. I've been working with the same studio on different shows for the last few years. And this year, I think because of the span protection, on the show that I just started, they had a clause in the contract that said they reserved the right to, it's a 10-episode show, to bump me up to $35,000 an episode to push it over the $350,000 mark. So my question is, are a lot of studios doing that? Is that common? And how often do they pull the trigger on bumping you
So we're fighting that language, and so far we've seen it just in ABC contracts, so I don't know if that's what you're referring to.
Yeah, it is.
So we do have a claim in the legal department, and no, it's not allowed. That's not the intent of the provision, as you know, indicated to us in the bargaining room in 2017. So that's not the correct interpretation of the provision to allow them to top it off and, you know, basically evade the span provision.
It should be guaranteed up front, is my read of it. It's the guaranteed amount, not the amount that you're paid, like $320
The
plus the
language is not
potential
helpful.
$30 they pay you to bump. It
The
should
language
be
is not
$350 in your
particular.
pocket, right?
Right, so, but the whole construct of the provision is, it pertains to your episodic guarantee. That's how that's how the provision starts. And so when we talk about how much you're receiving on the show, you know, our interpretation is you're looking at the episodic guarantee. What would you get? What will you get if they produce all those episodes? And is that less than $350,000? If so, that's exactly the type of situation where the provision was designed to apply.
So if in the next couple months they say, okay, we're bumping you up to that, what do I do?
Please call us. Like, in fact, you can even talk to me on tomorrow or Monday and send in your agreement, so we have more of them, because we are looking at all of those.
Okay, yeah, you have my agreement, so I'll talk to you.
Okay.
I mean, depending how many weeks they make you work and so on, it may, and how much you are paid, the result may be the same in certain circumstances, but not in others, and it's not a fair provision generally.
So, you know, to the extent that the company argues that, okay, SPAN applied at the outset, but then once we reach the 350, we're going to stop. That's also not the intent of the provision, and we do, you know, that's what we know. The intent of the parties was not to have that happen when we were in negotiation.
Over here.
Hey, I'm Anthony. So my question has to do with a series. I'm on a series right now, and I've noticed that, speaking with some other friends, that it applies to them as well. The order originally was for 13 episodes in the first season. The studio then decided that the first season's actually 10 episodes. So that they're holding 3 episodes that will be written and produced. This is for an animated show. And now they're ordering another 5 episodes to be written. All of these will be written under the season 1 contracts. So they're, you know, arguably getting 8 season 2 episodes written under season 1 rates. I was wondering what sort of language could be used or put into our contracts to prevent this sort of thing. And this is animation, yeah.
It is covered under the Guild agreement?
It
The
is.
series? Okay.
Oh yeah, yes, it is. Yeah.
Yeah, I mean, that's the tricky part about the episodes produced guarantee. It makes it really difficult, but let us take a look at that and see exactly what they're doing, because it might be a violation. Oftentimes it comes down to the language in your individual contract.
Okay.
But we'd like to look at that.
Okay. And you know, if anyone were to run into this soon, what kind of language? Are there certain phrases or, you know, definitions that we should try to put in?
Can you try to cap the season? I mean,
Yeah.
like a season
A
is
cap.
only X episodes, and beyond that, you're talking season 2.
Right.
Or you can call it season 1, but you'll pay me season 2 rates.
Right.
You'll move me into the season 2 deal, even if it's a season 1 deal.
Yeah, I mean, we have seen the situation where a company says they're going to produce 10, and then they say, oh, well, let's produce another 10 and call it season 1.1
Yeah.
or 1.2.
That was the issue with Disney Channel supersizing. What they
Yeah.
used to call, they'd be like, congratulations, season 1B got greenlit. And everybody was like,
yay.
there was an expectation that 10 episodes and you were done, we were going to the next one. But they were like, no, it's 1B, same rates, 10 more episodes. So yeah, more employment, great.
For
but
what it's worth, this is Disney.
I feel cheated.
Yeah. Yeah. Disney's getting wild, you guys. So just,
Yeah. That's why my shares are going up.
Over here.
I've written a 6-episode thing, sort of like what HBO did with Chernobyl. It's already written, and I've written a book and published that as well. And so it's already in format. I don't need a writer's room. It's 6 episodes, and it's already there. So say I go to, well, through this thing we've got doing with the Writers Guild, our website, I have already had a production company want my scripts, so I gave it to them. They have a deal with Amazon Studios, so I got to be ready. They may say no, and they'll start from scratch. But if they say we want to do something, I need what kind of because you've been talking about writers' rooms. I don't have a writer's room. I am the writer. And afterwards, they did a podcast where they told the historical truth. I've done the same thing. I've got a thing going like that too. So what kind of a deal do I look for?
So you're right, you don't have representation right now. You're saying?
Not yet.
Yeah, I don't know if some of the guidelines, and if some of the
I don't
guidelines that
represent
we're
it, yeah.
putting out for development season are applicable. This is more of a mini-series, it sounds like. We can help you with some guidance on that. I don't have numbers in front of me for that, but definitely we can talk about it. If you want to call We call the agency department because they're actually doing the intake for inquiries for people who need some assistance in negotiating.
Okay, all right, thank you.
Something else popped into my head, talking about separated rights and everything else, negotiating very aggressive reversions.
Yeah, so reversion is an automatic right. If you write an original pilot,
Right.
that can't be bought out, by the way. That's not part of the upset price procedure. That's why the rights end up being split between the writer and the company. Those rights revert automatically. So, I mean, that's already pretty aggressive, and you don't have to pay. The only time you have to reimburse for the television rights is by paying, if you need to reacquire exclusive rights in the pilot. But then you're left with the issue of the reserved rights.
Right.
Last question from this side.
Hi, I'm Michael Tabb. If I wrote a home video film, but was classified in the writing of it as a TV film, should I have been retained to write the first rewrite on it? Because they had the director immediately come in with their girlfriend and rewrite it.
It was classified. It was originally classified in your agreement as TV or as.
It was classified as a
DVD.
television for movie. It was. They didn't call it an MOW, but it was 120 page. It was a direct to DVD, but it was classified as a television in the agreement.
Yeah. So if it is television, it's a television agreement, and it's original, meaning the characters and the story are original.
It was inspired by previous IP.
That's the questionable part, but
Yeah.
to the extent it's original.
Well, they gave me story credit on both. The
Yeah.
WGA, I got story credit on both because it was very different spins on.
I mean,
something.
if it's
It
original.
was
and it's-
considered original because I got story.
Yeah. Yeah. I mean, so it comes down to the factual question of whether it was actually original, but assuming it was, then you are entitled to the first rewrite on that. So, yeah, call us and we can investigate that. Call the
Interesting, and
contracts
thank you.
department. Sure.
And then we'll go to our last two questions on this side.
Hi, Danny Tolley. I was hired on a show as an executive story editor, and the studio offered, instead of a weekly, a rate for episodic, which was new to me. And this particular show is a 13-episode order, so spam protection wouldn't apply to it, but had it been less than, as an ESC, the first part of my question is, does that mean that spam protection wouldn't apply to me?
It does not. It does not apply to story editors or equivalent titles.
Okay.
Of which executive story editor is one.
And so I'll add to that a lot of my story editor and ESC friends have experienced this staffing cycle, so that's something that I think the Guild should be aware.
Yeah.
The second part of my question is, how can we, is there any leverage in terms of telling our lawyers, no, go back to the episodic, or to the weekly versus the episodic?
Well, in no event are you going to get below WGA weekly minimum. In that case, Article 14K. So a lot of times what we've seen is if they do have an episodic fee for story editors, they're below minimum anyway by the time you spend 2 weeks or more or so on an episode. So generally, in those instances, you're going to be getting 14K minimums, which is just below $7,000 for a 20-week guarantee.
What we would do is say, look, you can quote it however you want, but in no case less than, maybe in this case, Article 14 plus 10% or plus 5%, whatever it is. So they can amortize it however they want because you're not protected, but now you're trying to get it to a weekly equivalency plus a percentage over it. So you're protecting the overscale.
Thank you.
Thank you.
Hi.
Hi.
I had two questions. One, do the streamers pay residuals, and how does that work? And two, do they pay character payments, and how does that work?
So if you're talking about high budget subscriber video on demand, the answer is yes to character payments. It's a lot like television. And yes, they pay residuals, and it's a pretty complicated formula when it comes to HBS VOD. Depends on the number of subscribers, depends on the year of exhibition, other factors. So that it's complicated, but yes. If it's non-HBS VOD, what we call original new media, then chances are you'll have to negotiate for residuals, and no, the character payment provisions won't apply.
So there's no residuals or character payments for low budget.
Correct, or, yes. The one exception to that is derivative new media, which is a sort of a subset of non-HBS VOD programs, which means that the new media program is based on an existing television motion picture or television series. It doesn't happen very often.
Okay, thank you.
Thank you. And I think as we wind down here, maybe we'll let each person on the panel offer one takeaway for everyone. Karen, we'll start with you. What do you want writers to take away about understanding their contracts?
Well, you're writers, you work with words, you should try reading them.
Thank you, entertainment lawyer Karen Robson. Brant.
That's untoppable. We should end there. But I couldn't. I could just tell you guys, this is less about the contract, because she's covered that. But I would say we are, my company, we are thrilled to see you guys through this whole action becoming so entrepreneurial. And part of that is understanding the business you're in, which also, I would say, our clients who know more about it and are empowered and we're not creating a dependency with them, are the happiest ones and the most successful ones. And so the stuff that we've seen you guys do with the portal at the Guild, with the hashtags and the staffing boost, with the mixers, and even with this, trying to understand and really wrap your head around your career, you should keep that all, even if and when this action ever stops. I think you guys have actually enjoyed it. If you want to keep doing it like Grant. If you get sick of it, you don't want to be your own auto mechanic anymore, then find an agent. But it's really been our pleasure to see you guys become so empowered. And we also think on some small level, it builds an appreciation in you for what we do all day. So,
great. And Laurie?
So my advice is send your contract to the Guild. It's pretty easy to do because we have a website upload link that you can use. You don't even have to mail it. And call us with questions, and obviously pay attention to the terms that are in there, and also what's happening once you start getting paid too, because that's where problems can arise. It's not just the contract, but how it's put into practice.
And the last word goes to writer and maverick dealmaker Grant Scharbo.
How much time do I have? I will say this. I think we work in a system that depends on writer ignorance about these issues. As we've learned with the packaging fee situation, very, very few people even understood what was going on until the Guild took action. So that act was in terms of back end, was the biggest pay raise we'll ever see. Because once you eliminate that packaging fee, that money goes into the pot. So in the same regard, you need to understand your business and you need to understand your deals. While you do pay handsomely for the expertise of these folks at the other end of the table, and their expertise is worth a lot, and I would never encourage anyone to do what I'm doing, even though it's not hard. But no, but some, it's not, and I'm saying that because, for me, if you're trying to weigh how much is that expertise worth, right? And is what I give up, they know a lot more than me, but is what I give up worth 15%? So it's a math equation. But what I would encourage, even if you have agent, manager, lawyer, understand these deals, understand what is important to you, what to ask for, prioritize your deal points. And if they say, this is as far as we're going to get, and you're not happy, say no. Until you start saying no, until you stay, we are the content creators. We have far more leverage than we're led to believe. So embrace that, use it, but use it in every aspect of your business, not just your writing. Those are my parting words.
That's great. How about a big round of applause for our panel? Thank you all for coming.
And thank you, Travis.
Thank you, Travis.